Hello, welcome to a, a new session. Our session titled Conflict of Laws Rules Applicable to Negotiable Instruments. We have two presenters. One, it's me. I'm Dr. Sagi Peari. I'm from University of Western Australia Law School. And we have another presenter who is Professor Benjamin Geva from Osgoode Law School. One presenter is from Australia, that's me, and the other presenter is from Canada. We very much enjoyed working together on this presentation, and this presentation very much based on our work, actually book, which was published with Oxford University Press, titled International Negotiable Instruments. We will talk more about the significance of our work towards the end of this presentation. So this is our plan for today. Basically, we're going to talk about five things, 5 topics. First, we'll start with the music of negotiable instruments. Music, the famous phrase made one of the giants of negotiable instruments. By music, we mean the very nature, the core aspects of negotiable instruments, the very idea of negotiable instruments. Then we will ask a question, do negotiable instruments have a future? Because of the historical background, because of the digital age, which is also the topic of this conference, we will ask this question, and not surprisingly, the answer is going to be yes. And if the answer is yes, the other parts of our presentation today actually will deal with conflict of laws. This is the areas that most of you familiar, question of applicable law, and we'll talk about the present rules of conflict of laws, the present rules of applicable law, applicable to negotiable instruments, and we will show that there's a major problem with present rules, and we will try to present this problem, but we also will try to explain the nature of the problem. So we will talk about the reasons behind the outdated rules, the reason behind the problematic rules which are today. And finally, we will make some comments about the potential reform, the potential way to improve the law, the potential way to reform the law. So this is our plan for today, fairly ambitious plan. We will try to make it in 40 or so minutes. But let's start with the music of negotiable instruments, and we are so lucky to introduce Professor Benjamin Geva from Osgoode Law School, fortunately my co-author on this project.
Well, thank you very much, Sagi. It was my pleasure to work with you, and thank you very much for your kind introduction. So essentially, when we do speak about what's negotiable instrument, then we have to think of, well, we start the example here, the bill of exchange, that there is a party, it's called a drawer, that writes a request, an instruction on a piece of paper to another party, that the drawee instructing the drawee to pay a certain sum of money to a third party, the payee. And the point about it, that it's not just an obligation written on something tangible, but rather the idea is that this monetary obligation to make the payment, which is attached to this drawer's order, is then locked into the tangible property. You cannot separate anymore between the right to the piece of paper and to the right to the shows in action, the claim towards the drawer. Now, the payee who physically receives this piece of paper, then signed by the drawer, becomes the holder who can enforce it. However, instead of just enforcing it, the payee may pass it on further to another holder through a procedure called endorsement, under which the holder signs the back of the instrument and transfers the instrument to a third party who becomes the holder. And this is known, what is this? This is a feature of negotiability. This is a transferability by delivery, plus the endorsement when the instrument is payable to the order. If the instrument would have been payable to the bearer, then it would be enough just to transfer the piece of paper as is to the transferee, so that this transferee would become the one who is able to enforce the drawer's obligation. Next. So basically, the holder's right to enforce the monetary obligation hinges on two aspects. One is that there was the physical transfer of the instrument, and second, the rightfulness of the transfer, which is usually executed through the consent of the transferee. And of course, it is a transferor, his or her signature, and then the transfer of the instrument, which then contract both the transfer of the right to claim from the drawer and also actually the right to claim from the transferor, the endorser, on this piece of paper. Next. So there is here, more specifically, I did speak about contract and obligation. So the idea is what the contract, the drawer didn't promise anything, the drawer just gave an order. But by issuing the instrument and signing, the drawer contractually guarantees to the payee and to any subsequent holder that the drawee will accept and honor the obligation under the instrument. And that the point of this guarantee is that if the drawee then does not comply, then the holder can go after the drawer. Now, the drawee, by just receiving an order, the drawee does not become contractually liable. It would be a very bad situation in life if somebody could give me an order and thereby I would be abide automatically. So for the drawee to become liable, then the drawee has to accept, to agree with, technically it is accept, which means to accept the instruction, to accept the order of the drawer. By signing his or her acceptance, the drawee undertakes an obligation to pay the specified amount of money to the payee, and of course, when the instrument passes on, any subsequent holder. And critically, this liability of the drawee hinges on the acceptance of the obligation through her or his signature. So that's otherwise, as I said, the drawer guarantees that the drawee will do it. But if the drawee does not do it, then there is a recourse against the drawer. But if the drawee does sign and they accept, then that is the main. It becomes in primary, we'll say, primary party to the instrument. And then once the payee transfers it, as I said, it is not just a transfer. The endorsers, there is a contract by the endorser, and by placing a signature on the back of the instrument and transferring to the new holder, the endorser guarantees the obligation of prior parties. So the holder basically has the obligation of the next holder of the payee endorser, of the drawer, and if the drawee signed, also the drawee as an acceptor. Next. And here is again, we are getting to we were talking again about transfer and obligation, but the point is to remember the basic is that you have to have a physical possession over the instrument, otherwise you are not a holder. Of course, there are situations that you have a right to possession, and you may have then a right, but then you are not a holder. In other words, there is, by the mere fact that you are saying the word holder, we do say that you hold something. It has to be physical possession of the paper, and also the obligation has to run to you in the sense that you are either the payee or the endorsee, or if it's a bearer, then you are the bearer. and then it is the crown, the or if I could say maybe in a different way, the darling of the law of negotiable instruments is what between the Anglo-American system, Anglo-Canadian American system, Australian system, called the holder in due course, and there is that you get the instrument free from adverse claims and defenses of prior parties. So just to put a simple example, if the drawer did issue the instrument in payment for an obligation that the payee owed to him, and the payee then broke the contract, the drawer would like to scream defenses when, well, to plead, say scream defenses when the drawer is sued. But if the holder is then a holder in due course, and the instrument was negotiated to him or her properly, then these defenses are overcome by the holder, as I say, who is a holder in due course. I will now give the floor to my esteemed colleague, Sagi.
Right, thank you so much, Benjamin. So what were actually the three classical types of negotiable instruments? And we actually go into some historical background of the payment mechanisms. You probably heard about something called a bill of exchange. This is the classical negotiable instruments when we have actually the drawer signs, delivers the instrument to the payee, which in turn may present it to the drawee for acceptance. Bills of exchange were actually used widely in international commerce and still used in international commerce. Many of you still remember checks, and in some countries we still use the checks. Generally, checks follows the structure of bills of exchange when the financial institution, the bank, is the drawer, or the drawer represents the drawee. And we have the also another type called promissory note, another historical type of negotiable instrument, when the three-dimensional structure of negotiable instruments is reduced into two actors. We have note maker who makes a direct obligation towards the payee to make the payment. Those are actually the three classical types of negotiable instruments. They have really deep historical roots, as Professor Benjamin Geva shows in so many of his works. Now, the key question, of course, it's a tricky question. Do negotiable instruments have a future? And some say the answer is no, but we do think that the answer is yes. And many also hold this view. So why do negotiable instruments have a future? Because first, they do actually produce a delicate balance between the rights of the parties, between the interest of the parties, between the obligation of the parties. And this balance has been achieved through centuries of hard work of courts, of mistake, hesitations, and continuous drive toward justice. So instead of limiting his options to contractual obligation of the drawer, the payee receive a piece of tangible property which could be enforced against the drawer, acceptor, and the endorser. This is much more than a single contractual obligation, frequently involving serious burdens from the perspective of litigation enforcement proceedings. So it could be actually, in other words, it actually could be a good option for PE. At the same time, it is much less than making a payment at the time of the contract formation. The difference is critical for the drawer, who may use the available funds for other purposes and have some option to resist the enforcement of obligation against her or him. In other words, it's apparently the negotiable instrument, the law of negotiable instruments represents some good, delicate balance, which leaves both parties half happy, which is great for commerce and great for law. But it's not just about a delicate balance. It's all about also about digitalization. So apparently we have today, if you look deep, comprehensively at the very structure of negotiable instruments, we can delineate two central features of this structure. One, signature, the other one, physical possession. So apparently both aspects could be actually transformed and could be actually presented in digital age. So signature, electronic signature could be electronic signature, and this has been electronic signatures have been recognized through international conventions of United Nations and the UNCITRAL, and they were also implemented in domestic statutes across jurisdictions. Also, possession, another key concept of a negotiable instrument. If we actually follow the underlying idea, underlying rationale of possession, this seems to relate to exclusive control. And in other words, both signature and possessions, the two key aspects of negotiable instruments could be actually rationalized in digital age. And I think we think that the recent Law Commission report in UK on electronic trade documents follows those ideas that signature and possession could be relatively with relative ease to be transformed to digital age, which is really important. And this actually suggests that negotiable instrument could receive their digital form. So what are the actually options today? So first we have option of cash payments, which is not actually a good idea, a good option, because it's many times it's troublesome to carry cash, but it's also risky and also run against the interest of the person who makes the payment. Online payments, again, it's actually very easy to do it. But once again, it's problematic, especially in the time of contemporary age of consumer protections, when the consumers pay in advance, pay online, and afterwards it's really expensive to engage in litigation. So from consumer perspective, from the perspective of the person who pays, it might be not a good option to make online payment. Credit card, another option, but also frequently triggers interest to be paid by consumers. The chargeback process remains complex, time-consuming, and frequently the credit cards place risk on the consumer or small business. International trade, generally, negotiable instruments could be actually represent a tiebreaker when we have a situation when the parties prefer certain methods of payment. But following the origins of negotiable instruments, we can say is that as a tiebreaker in the case of international trade between parties from different countries, actually negotiable instruments could be a good option as a tiebreaker, as a compromise. But in addition, cash payment, online payment, credit card, those actually options that could actually coexist together with negotiable instruments. Digital negotiable instruments could actually provide another option, right, alongside other methods of payments. In other words, if we think seriously about our liberal tradition of to provide more options, more choices for people, digital negotiable instruments with their history could provide simply another option, which is probably it's a great advantage. Now, let's move now to conflict of laws context. And in the context of conflict of laws, we do have some key provisions, very old provisions. For example, Section 72 of the UK Bills of Exchange Act, which effectively says that we need the foreign element. And those of you who, most of the audience know conflict of laws. In other words, it's a significant requirement to demonstrate a foreign element. So it's actually a requirement that limits the number of potential foreign elements to four elements. It can be the place of drawing, the place of negotiation, the place of acceptance, and place of payment. So the idea is to say the law says today, based on Section 72, which other jurisdiction also follow based on UK bills of exchange, which other jurisdiction modeled on the UK bills of exchange. We do have this foreign element requirement, which also we have another significant foreign element aspect of traditional law in Section 4 of Bills of Exchange Act, which actually makes a sharp distinction between domestic and foreign element. When we say that domestic element, it's only applies to domestic instrument, only applies to negotiable instruments, which was drawn and payable in the UK, in other words, in domestic state, or it is drawn in the UK and the PE is a UK resident. All other instruments are foreign instruments. And then there's a further application, fairly significant application to this sharp distinction between domestic and foreign instruments. So we have two levels of foreign element requirement, one in Section 72, and the other one in Section 4. The other major thing is obviously the general rule. And the general rule is highly problematic for everybody who is involved in conflict of law industry, is place of contract formation. The old rules that was actually condemned by all or the vast majority of conflict of law literature still exist, surprisingly, in negotiable instruments. Section 72 embraces this rule. Now, it's obviously a question, what does it mean in the context of negotiable instrument, place of contract formation? We think this is the place of contract instrument delivery for each one of the contracts. If you remember, the three contracts under negotiable instruments law structure. But the idea is that we still here, in this area of law, we still follow the place of contract formation, which is highly surprising for everybody who is involved in conflict of laws. This rule was effectively abandoned long time ago in all major jurisdictions, but still present in negotiable instrument law. Now, in addition, we have Section 72. In Section 72, there are some exceptions, provisions, which support the validity of the instrument, very much in relation to contemporary provisions, which support validity of instrument, provisions which provide another route, which would actually validate the instrument, which very much follows provisions which support validity of contracts in the context of conflict of laws, provisions that support the validity of contracts, situations that the contract would be actually valid. Now, obviously, it's highly problematic. And what is interesting, it's not just in a UK Bills of Exchange Act. We see same problems in other rules, other conflict of law rules of negotiable instruments. I'm talking about the Geneva Conflicts Convention, 90 years old, which follows the connecting factors of place of signature, place of payment, place of nationality for various situations. It adopts the doctrine of renvoi, okay, the condemned doctrine of renvoi in part, but also supports validity of instrument. The American secondary statement follows connecting factors of place of payment, place of contract formation in relation to different situations. And we have the Inter-American Convention, which was not broadly accepted, but also has significant connecting factors of place of contract formation, place of payment, and supports validity of instruments. Here's the question, and what is the reasons behind these outdated rules? And everybody who is involved in conflict of laws area knows those rules are, majority of them are outdated, especially on the point of contract formation connecting factors. And what we argue in our books that probably there are several reasons, one of the reasons, this is the rhetoric of law of merchants, saying that, oh, negotiable instruments is something different. It's not contract, it's not property. It came from law of merchants, something is that unrelated to the state, unrelated to some historical development. And we challenge this. We challenge this argument. We say no. Negotiable instrument very much based on contract and property, tangible property. We just simply need to adjust the traditional doctrines of contract and property, tangible property, to negotiable instruments. But unfortunately, Rome 1 Convention and following Rome 1 regulation simply excluded. They excluded negotiable instrument because of what they call complexity, special nature of negotiable instruments from the scope of the new rules, from the new rules of conflict of laws. And this is actually what explains what Dicey and Morris said in their recent edition. We'll see what will happen in the new edition, is that negotiable instruments law, conflict of law rules in relation to negotiable instruments law require revolution. Okay, they require dramatic overhaul. They cannot actually remain the same. And we think the problem was actually with this rhetoric of complexity, rhetoric of special nature, rhetoric of law of merchants that left the negotiable instruments outside of the major reforms of the recent decades, especially in the area of contract law and in the area of conflict of law rules applicable to contract law. And this is unfortunate. And this is why we think Dicey and Morris calling for revolution, for dramatic overhaul. So what is the actually contrast for the reform? So we do challenge this special nature or complex nature, the stigmatization of negotiable instruments, saying that, oh, let's leave them aside. Regular property law or tangible property law rules or conflict of law rules and conflict of law rules do not apply. Okay, we challenge that. The other thing, major thing, is obviously the party autonomy principle. Okay, now this principle we consider should be applied to negotiable instrument to place it on the face of the instrument. Okay, this is what we suggest, because this principle facilitates certainty, predictability, and obviously liberal autonomy. It's all was acknowledged by conflict of laws literature. This was the major purpose, acknowledged purpose of Rome 1 regulation on contract law. And we don't see a reason why to actually exclude negotiable instruments from this major development. Party autonomy on the face of the instrument, should be the point of departure for conflict of law revolution of negotiable instruments. Now, obviously, the foreign element requirement. We have obviously Rome 1 regulation. It's fairly vague on this point, but there's a clear literature which challenges this clear distinction between domestic and foreign instruments, and clearly the contemporary conflict of law jurisprudence offers to eliminate, or at least to mitigate, this aspect of conflict of law doctrine, according to which the foreign element must be shown, must be present in the factual metrics of the case. Okay, the present provisions are very harsh and in terms of these foreign element requirements. The other aspect that we actually do suggest is actually considers the connecting factors. The connecting factors. Obviously, the connecting factors of contract formation, it's highly problematic. We have so much literature on this. It relates to the sovereignty principle. It relates to Joseph Bill's amorphous theory of the vested rights, which follows the last element in the party's liability. It was mocked. It was condemned by all major scholars, and actually the place of contract formation was actually eliminated from all major areas of contract law. It's simply too old and actually represents a problematic theory. It's also highly problematic from the perspective of digital age, and highly problematic from the perspective of flexibility and complexity of commerce. So we actually clearly challenge the place of contract formation rule. We do offer to consider other places, such as factors which relate to the parties themselves, okay, such as place of residence, and very much this suggestion relates to the approach taken in a convention of the law applicable to certain rights in respect to securities held in terms of intermediaries. And we think actually this was a good development which negotiable instruments should follow. Now, there's actually in the Bills of Exchange Act, the UK Bills of Exchange Act, as I mentioned, there's some exceptions to the general rule which supports the validity of the instrument. And that's okay. This actually follows the contemporary doctrine. What is not okay, if we look carefully on those rules, of those exceptions, they actually discriminate, or they actually favor the domestic law. If you look carefully on those provisions, they actually do not legitimize foreign instruments that are not valid under the domestic law. In other words, the present language of Bills of Exchange Act is actually problematic, because actually prefers domestic law over foreign law, which is, you all know, highly problematic from the equality of law perspective, which is today we recognize in conflict of laws doctrine. And finally, obviously, Renoir was actually a doctrine which was actually condemned in the last decades, and we don't see a reason why this is something that should not be challenged in the negotiable instrument context as well. Same point applies to nationality connecting factor, at least for common law jurisdictions. So obviously, in order to get the full grasp of our argument, you really need to read the book. Okay, so the book was published with Oxford University Press. It was published in December 2020, so a year and a half ago. In this book, we actually provide a very significant outline and explanation of this complex special nature of negotiable instruments, which very much based on contract and property. And this is exactly what allows us to make the further step and to explain why the present rules of negotiable instruments must be reconsidered. This is what Dyson Morris called dramatic overhaul. We think that party autonomy principle needs to be introduced, place of contract formation must be reconsidered, and same point applies to Roy and the paternalism of some rules of conflict of law rules applicable to negotiable instruments. This is what we have to say about negotiable instruments. Negotiable instruments do have a future, and that is why the conflict of law rules applicable to negotiable instruments must be adjusted and must be reconsidered in light of the present reality and digitalization. Thank you so much.